There we go. So after tonight's class, we'll actually be halfway through the semester, which is pretty amazing. But of course, it's a spring semester, so it's to be expected. So hopefully you're starting to get into the whole concept of the laws that are relative to sports, athletes, arenas, coaches, all the kind of things, and participants that are important in sports themselves. Before we start the lecture tonight, a couple of things. So firstly, as you all know, I sent you a Google form for the film study last week, and it's dealing with the film Concussion. So it's a film with Will Smith, available on Netflix, as far as I know. It's available to you up until Friday. So Friday at 5 o'clock is when I'm looking to get your film study back, and the instructions for it are on Moodle. Second thing are the group presentations. So I've asked you to put yourselves into groups of 5 or 6. I was hoping that it would be done for tonight's class, but it hasn't been. So I'm going to put you into groups. All right, I'll put you into groups after tonight's class. I will send everybody an email tomorrow with the groups. And then so once you acquaint yourself with whoever is in the group with you, then I will ask you to choose a topic. Actually, I'll ask you to give me your best 2 topic choices. So in the event you don't get your first choice, hopefully you'll get your second choice. And again, all the instructions for the choosing of the topics and what have you is on Moodle under group presentations. Anybody have any questions on those 2 issues? Okay, before we start the discussion on the video I had you watch, which was about half an hour long on the NFL and domestic violence, it was a pretty intense video. I'm going to share with you the screen tonight, our PowerPoint, only because there's a very specific video on it that I want to take you to, which is it was shown in a bit in pieces in the video I asked you to watch, but this is the actual original footage of Ray Rice knocking out his fiance in an elevator. So we're going to watch this, and then we'll talk about, for the purposes of participation, the video I had you watch before class. You watching that video? Okay, so I'm going to stop sharing that for the time being. We're going to come back to it in the lecture itself. So does anybody have any comments on that particular video, Ray Rice and his fiance, and or the discussion that took place in the video? It was a dialogue, essentially, that took place that I had you watch. Jenyen?
Hi, Professor. After I watched the whole video, before the class, like I have the three questions after I watched this one. Is that like the background of this case is that the victim Janae Permer was used to domestic violence by her fiance Ray Rice, but she eventually married him. So the first question I have is that possible for Janae's performance as the Stockholm syndrome? Because in other cases, are also examples where the victim has emotional towards to the criminal. If the victim insists on protecting the criminal in the actual case, will the judge generally cancel the punishment decision to the criminal? And the second question I have is that possible that Janae choose to forgive her husband in the public media because of the interest of the whole instance? Because Ray Rice was punished by the NFL and the courts after this instance and would lose $10 million income, which is wealth that most of the American people cannot earn in their lifetime. So is that possible for she make that decision just because of the money? And the third reason I don't really understand is uh, like why the police officer had to arrest both Janae and Ray after this things happened, because also the video proved that this was like a mutual assault. But the end of this case was that Janae was the one who get like a serious injured. And as a professional NFL player, Ray must know that his attack power. So he should really have the absolute responsibility. In the legal system of some countries, what I know, like Japan or Singapore, if a professional martial artist or antagonistic athlete fight with someone on the street, it can be considered as armed attack. I'm not sure is that the same as USA.
Okay, well, that good questions, Genwan. I appreciate that. So let's see what everybody else in the class has to say, and then if it's not answered in other questions and answers from your classmates, then I'll come back to them directly as well. All right, so Shivani?
Okay, so I think the first thing John was saying is that if she could like retract the crime, the whatever he had done to her, like for example, not so he isn't penalized for the crime. And I think that is possible because I've known of similar situations in, for example, my home country, Jamaica, where it was on the news where a female was abused by her husband and it went to court. And in the middle of the courtroom is like the guy was pleading to her that, okay, I'm sorry and I'm gonna do better. And he proposed to her in that same courtroom, and she basically retract all the claims against him and the case just died out. And then in the end, he abused her again, and then they're all going to court again. So yeah.
Okay, Abigail.
I think the biggest part I was focused on was when they were talking about in that discussion thing, like, should the NFL punish him or should it just be left up to the courts, which I found kind of interesting because, like, sports law is kind of different because sports become the person's like whole life as opposed to it just being a job. And I think they were kind of alluding on to that. But I think at the same time, like, say that happened in a regular job, you know, it was found out that an employee beat their fiance, knocked them unconscious on an elevator. I feel like that job would possibly also give them repercussions. So I don't know.
Sure. Anybody else have comments? It was a pretty dramatic event. Kara?
Yeah, I find with these cases, the woman was talking about why she thinks they were hesitant to impose a penalty on him because, well, he's a good player. He's his household name. He's making us money from an ownership perspective, the organization. But I wondered, is it as common now that kind of dependent on how popular a player is or how skilled they are, kind of that comes into effect with the punishment if teams are more hesitant to suspend them or terminate them, dependent if they're a practice squad player or a star of the team?
Okay, well, the information I have, and every league now has a domestic violence policy. So it almost always now, and this incident was now 7 years ago, it almost always now involves almost virtually an immediate suspension. And depending upon how the league approaches it, it could be a suspension that could be significant. So, for instance, in baseball, suspensions often go, if not half a season, an entire season, which is multiple millions of dollars. And this is before, and this is what the lawyer on the panel was talking about. This is before there's actually a finding of guilt. So it's a very serious kind of thing. Shivani, your hand was up again.
Yes. And next thing that I found like alarming is where I think the journalists were saying that, okay, if he's arrested for like a case like domestic violence, he's not like suspended from the game, he can still play. But if he's convicted, that's when they'll withdraw him from the game. So like I find that really alarming, because if someone is involved in a case such as domestic violence, the first thing that you should do is just withdraw him from the game, because I mean, that's not a good image you want to like, promote, because him playing is like, okay, they're saying what he did is okay, you're not penalizing him for what he had done. So I find that really alarming.
Well, and that's a good point. And we're gonna talk about this tonight when we talk about how teams and leagues are their own tribunals, in that they make their own decisions for their players within the tent of their environment. Kara, is your hand up again?
No, sorry, I just forgot.
Sorry.
Yeah.
Okay, all right. Another thing too, and this goes back to what Jenron was saying at the beginning, is, for instance, and again, it's different from jurisdiction to jurisdiction, but in Ontario and virtually every municipal police service in the province, they pretty much have a zero policy tolerance policy, which simply means it doesn't matter if the victim, in this case, is Rice's fiance, decides that she doesn't want him to be going through the court process. She wants to have the charges dropped, all those kind of things. The police don't pay attention to that. That's not their policy. Their policy is to go to trial anyway. Now, that doesn't mean that she, would not go on the stand and basically not say anything. But if that was the case, then she'd be facing an obstruction of justice charge. So, we do have a zero tolerance policy, in Ontario. That's not to say that, that's the case in all of the 50 states, because, and I mentioned this earlier in the course, each state has its own criminal process, right? Canada has one criminal process overall, but each state is individual with their own criminal codes. So, and all police services have, again, their own policies. So I honestly can't tell you how many jurisdictions deal with that kind of thing. The interesting point that was made, and this is brought up earlier by you guys, is that in the second example of domestic violence that they were talking about on that panel, and I didn't take down the name, where the NFL was arrested for felony battery, all right, which we now know battery is the actual hitting, that the league took the position that, or the team took the position that, he could still keep playing until it got to court. And the way around that, of course, was that, and this is very, very common in all jurisdictions, is that for first-time offenders, there's often a diversion process made available, especially in domestic assault, where the courts realize, and the criminal justice system realizes that to a great degree, sometimes, or most times, in domestic violence, the couple are still a couple after the event. All right, so they don't necessarily aim toward a criminal record for the person who did the offense, but there certainly is taking responsibility for that, and almost always couples therapy and what have you. And clearly, if it happened a second time, the diversionary process wouldn't be available. It would go straight to trial and a conviction if that's what happened at trial. So the woman on the panel had a lot of problem with that. She was really insistent on that somebody who had hit somebody should have immediate repercussions with respect to their professional careers, and obviously the lawyer in the panel would be the person who would say, look, we still have a presumption of innocence, and he didn't actually say that, but that's what he was talking about, in our systems of law that, yeah, and of course, when you have something as open, as transparent as Rice, being caught on video in the elevator, I mean, that just made it worse, right? There was really, really no opportunity for him not to be facing consequences because, he'd lost to a great degree that presumption of innocence because he was caught on video beating his fiance. But having said that, she did not want him to be convicted. She was his fiance at the time of the video, and she married him. Now, I honestly don't know whether they're still married. Again, all this took place 7 years ago, but I looked this up and I can tell you what happened. So that was in 2014. So Rice was indicted for assaulting his then fiance's, then to become wife. Obviously, it gained a lot of notoriety because of it being caught on footage and released to the internet. So that's why I have it in the class, and that's why you've all seen it. So following that, the team he played for the Ravens, they actually released him, right? They released him from his contract, and he was indefinitely suspended by the NFL. He appealed that, right? And he appealed that and was reinstated to play. But after being released by the Ravens, no team hired him, right? He was never picked up as a free agent, which simply means that this effectively ended his career, right? So, all of the arguments we have about whether she should have testified against him or she should have still married him or that she didn't want him to be convicted, all those kind of things. Well, you know what? In reality, the real world took care of it for her and him and everybody else who was offended by what he did, because it did in fact end his career. Right. So I have no idea what he's doing now, but he's not playing professional football. He never will be again, obviously. And there we go. So does anybody have any other comments about this event and or the discussion in the dialogue on the video? Jen Wan, was there any questions that weren't answered as a function of the back and forth in the class?
So everything's all clear. Thank you, sir.
Okay. Well, the third question you had was you're talking about in Japan and Taiwan. If you're an athlete, then you're basically armed. If you attack somebody, as a function of training, we don't have that kind of system in place in Canada. So nobody is going to be charged with a more lethal, more serious indictable offense simply because they are a professional athlete and are more skilled and clearly in better shape than whoever they attack. So we don't have that. Okay, so let's go back to the PowerPoint and do the class. So we won't look at that again when we get to it in class, but okay, so all right, so tonight's class is on, it's obviously on administrative law, which is referred to as the fairness in sport, right? So administrative law, I teach a class on administrative law. I don't know if any of you were in it. I taught it last year, so I'm not sure anybody was, but if you were, the entire class dealt with what it is to go before a tribunal, essentially, and have your issue adjudicated in a tribunal as opposed to going to court. So administrative law is an alternative to the court system, right? And most sports organizations are considered to be what are called private tribunals. So there are lots of public tribunals that are alternatives to court. For instance, the Ontario Labor Relations Board is a public tribunal where often, if you have employment issues kind of thing, you can go to have matters adjudicated. There's a residential tenancies board that's available for disputes between landlords and tenants, and that's a public board. Well, it's no different when you look at sports organizations, which can be the team and or the league and other larger organizations like the Olympics, what have you. They themselves are considered to be private tribunals, right? So they're not there for a public purpose. They're there to serve their own internal membership. And the thing about being a private tribunal means that they're autonomous, which to a great degree means they aren't influenced by other organizations and or courts, and we'll talk about exceptions to that, but that's what it means, courts. They write their own rules and they make their own decisions, right? And that's really, really important to know, because when you join a sports organization, you become part of the environment in which that tribunal operates, right? So again, the law that governs the operation of sports organizations is called administrative law, right? Courts traditionally are reluctant to interfere in the affairs of private tribunals. Any idea why that is? Any thoughts? It's fundamentally because of their expertise, right? Sports tribunals, leagues, teams, and what have you, have a very, very fixed set of rules that operate the playing of the sport and how it's refereed and playoffs and all those things that are organized in it, right? And so the courts, for the most part, take a hands-off approach. So how the league and its players interact and their coaches interact and what have you, the managers, everybody who's involved. Courts, for the most part, say, you know what, you're really the experts on how that game is played. So we're not going to interfere with, that operation of the sport for the most part. Now that's changed. That's traditionally that's the common law position. So that's what's evolved. And you guys all know that sports have been around for centuries, as has the common law. So that's pretty much what it was for centuries. But over the course of time, courts have gotten, a little bit involved in the arena of sports in a couple of cases. So the first case is where there's some dispute with respect to what are considered to be the association documents. So the documents that actually create the sport itself, all right, and create the league and the teams that are in it. So, and these documents represent the contracts between the organization and its members. So courts will get involved to some degree with that when it's a legal issue, and we'll talk about that in a few minutes. And they likewise, and this applies to all areas of administrative law, that they apply what are called the rules of natural justice, right? And they will apply those rules to the internal, as in decisions within the leagues or the teams themselves. They will apply the rules of natural justice to sports organizations, right? To ensure that in fact those rules are abided by, right? And again, natural justice in very broad terms means the duty of fairness. Anybody looking at it from an objective, reasonable point of view would have to look at it and say, yes, that particular action was fair or was unfair. And that's essentially how you determine whether natural justice was lived up to. All right, so let's go back to the first issue that courts take a look at, and this is the contract of the organization and its members. So the contract, it's like a social contract, just like we all are part of a social contract in society, where we agree that we elect people to make decisions for us, politicians. So whether they're in the Parliament of Canada in Ottawa or the Legislative Assembly in Ontario, we elect them to make decisions for us, and we give them the authority to make those decisions. But we totally, as a function of that social contract, expect them to abide by the law and to make decisions in our best interest. Well, so the contracts for sports are exactly the same kind of thing. Everybody who belongs to the sport in the league or the team, they see themselves as being part of a social contract within that particular purview of the sport or the league. All right. And the documents that make up that social contract in the league are the constitution of the league or the team, the bylaws, the policies and procedures, and the rules. So when someone joins a sports organization, so you think of this, the easiest thing to think of this can be professional athletes when they're drafted. The NHL draft, the NBA draft, the MLB draft, all these young players, when they are drafted, right, then that, and they accept the position in the draft, and almost all of them do, not always, but mostly, when they accept that position, they become part of whatever sports organization has just hired them, essentially. All right, so if it's a baseball draft or the hockey draft, it's if the Leafs draft you, right, then you become part of the Leafs organization, which means that you as a player are taken to accept all of those contracts making up the social contract of the team, right, within the broader context of the NHL. So when, you know, now you are likely, if you have just been drafted, you are likely going to be coming from a junior team, right? Basically, you know, if you're a Blue Jay, you're going to be coming from the Buffalo Bisons, right? There's all kinds of, or the Toronto Marlies, you know, for NHL. I mean, you're going to come from a junior team, which means you're already part of the organization. You're already being paid to play, but at the junior level before you join the show, before you become, you know, a big league player. But, you know, so you're already part of it. But sometimes, you know, sometimes athletes are hired who aren't in the junior system, and, you know, they come into it, you know, on a contract without a draft, for instance, and that's when they become part of this organization. But when they do, whether you're drafted or not, you know, as a player, you are taken to accept the documents that make up the rules and what have you of the league. You accept those, and you're taken to accept what's called the inherent authority of the organization to administer the social contract, as in to administer all of those important documents that pertain to how the organization is actually organized, really, right? The contracts cannot be changed unilaterally by the organization or its members, right? So when, you know, you join it, right, the team owners can't just change the rules of the league, you know, without the participation of the Players Association, those kind of things, right? However, having said that, if something goes wrong, a decision is made that falls outside the contract and the rules that everybody's agreed to abide by, then if those details of the contract have been ignored or not applied, then in that case, the courts will step in. The courts will step in to ensure that, in fact, the proper details in these contracts are abided by. Okay. With respect to fairness, the second area where courts will look at what a private tribunal such as a league does is that there's a duty to be fair. And the duty to be fair has these 2 points. The decision maker, as in somebody in the league who makes a decision affecting somebody else. So it could be a team making a decision affecting the manager or a player, or it could be a coach making a decision affecting a player. It could be the team ownership making a decision regarding the manager. You know, all of these interrelationships, you know, that are part of how sports are organized. Right. So with respect to fairness, if somebody makes a decision that affects you as a member of that organization, then you must be given a reasonable opportunity to present your case. So if somebody's made an allegation against you as a member of that organization, you have the right to respond to it. Right. And the decision maker, as in the person who is going to be listening, who now becomes part of that private tribunal, who listens to the dispute, you know, has to listen to both sides, the person making the allegation and the person defending that allegation, and to not act with what's called bias. And we're going to talk about the different kinds of biases that exist in the law of natural justice. All right. So firstly, with the right to a hearing. So firstly, the person has the right to know the case against them, right? And they have the right to respond. That's elementary. There are safeguards in place to protect these rights, and they fall along a spectrum. So I've given you this reference in the textbook. It's at page 54. And the spectrum basically goes, it's a spectrum of fairness as it relates to a hearing. So, you know, at the low end of the spectrum, where the allegation, you know, isn't that serious, it doesn't affect somebody's ability to play in a league, for instance, it's not going to terminate their contract, then, you know, it would be an oral interview. These are the decision makers, an oral interview and a response, right? And then going up the spectrum, it may require something in writing. That's a little more serious, right? And then further up the spectrum is a review of written submissions and responses and rebuttals, but still in a relatively informal setting. However, if it's a formal or complex matter, most particularly those matters that will terminate somebody's position. So the manager is being fired, the coach is being fired, you know, a team player, again, this is exactly what we were talking about earlier. A team player is being suspended for a season for domestic violence. That's a decision made by the team affecting the player. So that's an administrative law decision. If that's a very serious one, because that affects their livelihood. So that absolutely requires documentary evidence. It requires an in-person oral hearing. And then the hearing for the tribunal has to take place very much like how a court takes place, where the parties making the allegation put the case forward. the party who is facing the allegation gets the opportunity to cross-examine the allegation against them. They then get to put their own case forward. They will then be cross-examined by the person making the allegation. And then who is ever sitting on the tribunal itself to make that decision, was it fair to fire the manager or the coach? Was it fair to suspend Roberto Osuna of the Toronto Blue Jays for domestic violence? And that's a case like that's now 3 or 4 years old, but that's a real case. And he was suspended for a year, and he never came back to play for the Jays. That's the kind of thing that requires pretty much of a formal hearing within the confines of the team itself, right? And so the details of the case, basically, and the seriousness of it, and the disclosure of the case against somebody truly depends upon the seriousness of the issue. So again, someone facing what's called a disciplinary hearing is entitled to challenge the credibility of witnesses against them and to provide their own evidence rebutting that allegation. Okay, so we don't need to watch the Ray Rice thing again. All right, so the general rule is this: decisions withdrawing privileges already conferred, which means people are already in the league, they've already been hired, coaches, managers, players. Decisions that withdraw those privileges, including the right to make a living, require more safeguards than decisions conferring a privilege. So conferring a privilege is you want to become a member of the team, right? Well, the team does not have to give somebody who wants to belong to the team the same kind of consideration they do for somebody who they want to actually have leave the team. Hopefully that makes sense to you guys, right? So again, an example, canceling membership in an organization requires more safeguards than actually joining it. Belonging to and again, in the sports context, belonging to an organization is incredibly important, right? There are very few sports that don't involve belonging to a sports organization, even if you are in a sport that is not a team sport. So for instance, if you're a golfer, right, that's very much an individual sport. Now you've got a caddy and you may have some people in the background who are part of your team, but you're a player all by yourself. So if something happens and this is, in Canada or the US, where the PGA, the Professional Golf Association, is going to impose some kind of restriction on your ability to play, that's incredibly important, right? Because if you can't belong to the PGA, you can't be a professional golfer, right? So that's how important it is to make sure that there's fairness in how they're treated. Okay, and as a function of that fairness, again, we have the rule against bias. So organizations must make decisions without bias. Anybody want to tell me what bias is, just offhand? No? Abigail?
Bias is like favoring one side or the other for various reasons.
Yeah, it's favoring some, and it's also looked at, but you're absolutely right. It's also sometimes looked at as a prejudice, as it harming somebody. But a bias can be negative or positive. But you're right. Most often it's looked at as something positive. But in this case, it's looked at in a negative, in that there are two types of bias. So here we're talking about the tribunal, the private tribunal, who is deciding a decision within the context of a sports organization that affects somebody's ability to make a living. All right, so, the members of the tribunal who make it up are chosen by the organization itself. So it could be one person appointed to make a decision. It could be a panel of 3, 4, 5, 20 for that matter. It doesn't matter, but the league itself or the organization decides somebody will make the decision regarding some allegation against somebody, and it cannot be doing the decision maker, whoever is appointed, can't be having any bias. So it's either actual bias or apprehended or what's called perceived bias. So actual bias is exactly what it sounds like. The decision maker has a personal interest in the decision, right? So, within a league, the person who's making a decision about whether somebody can play or not can't have an interest in whether that person plays or not. So they can't, for instance, own part of their contract. So, they're gonna make or not make money if that player plays. There's all kinds of things you could think of, but that's the kind of thing. Actual bias involves pretty much a personal and direct relationship of some sort with the person who's before the tribunal, right? That in fact makes that connection untenable. So, and these are other examples. So, you have a prior or existing friendship with the person in front of the tribunal. You have a business relationship with somebody, who's coming before the tribunal, or you have a family relationship. So, for instance, somebody who's put, who's made the decision maker by the organization, cannot be making a decision on their son, their brother, their niece, whoever it may well be. That's just obviously too direct a relationship. So that's an actual bias. That's fairly easy to see. It's objectively easy to see, and therefore that person cannot be the actual decision maker. We also have what's called perceived or apprehended bias. And this is much harder to prove if you're the person who is facing the allegation and you're going to make an allegation of perceived bias. It's a harder road to hoe than it is for actual bias, because what you have to do is you have to prove that the person who's making the decision, that their subjective mind, it's not objectively reasonable to see bias, but their subjective mind, as in their thinking, is somehow affected the way they're going to make the decision affecting you, and that affects obviously the outcome of the hearing. So the test for perceived bias is this: would a reasonable person, which is objective, knowing the facts concerning the decision maker, suspect there would be bias? All right, so if you're the person who is alleged to have done something wrong, if you're Ray Rice, who beat his fiance, or you're Osuna, who was suspended for domestic violence himself, or doping, and we're going to talk about doping in our next class. And again, doping is a very big part of administrative law, because again, the leagues are the ones that impose rules regarding doping. So, in all those things, if you think that the person making the decision affecting you, you think that they're biased, then you have to prove it. And the test is, would anybody on a reasonable level look at the facts you're alleging and say, yeah, you know what, we think that's a perceived bias that may give rise to, more of an actual bias, and therefore they should not be the decision maker. So these are the relationships that give rise to bias. So relational bias, informational bias, attitudinal bias, institutional bias, and operational bias. All right, so these are pretty straightforward, and here's what they are. So relational bias is this: that a personal relationship that might suggest favoritism, such as friendships or family, or animosity, such as a prior personal conflict. So for instance, if the decision maker appointed by the league has bad blood with the person who's actually been alleged to have done something wrong, so there's some record somewhere that is objectively reasonable to see that they had a falling out sometime in the past, and that happens in sports all the time because emotions run very high. If that was the case, and the person who's facing the allegation says, you know what, this person who's going to make a decision affecting me, we've had arguments in the past, or we've sued each other, over items in the past. Well, that clearly gives rise to a relational bias, and that decision maker, really wouldn't be allowed to make a decision in that case. Informational bias is this: so the decision maker learns details about the person or the issue from sources that might taint their decision making. All right, so this is where somebody brings information to the decision maker about the person facing the allegation that they believe will taint the decision they make. They could be dissing them for any number of things. They could be making allegations against them that aren't part of the public record. So maybe they did something incredibly wrong in the past that didn't give rise to a criminal charge, but it's known to the person who brings it to the decision maker. That's an informational bias. So again, if the person who is facing the allegation can raise this, saying, look, this decision maker, he's been told this by that person that would definitely taint his decision making, for or against me, but obviously mostly against me, then that person should not be the decision maker. We have attitudinal bias. So if there's a decision made by the decision maker in the past that might indicate a predisposition to make an adverse decision now, that's attitudinal bias. So what this simply means is that the decision maker has already in the past made a decision affecting the same person before. And obviously the decision didn't go in favor of the person before them, right? So, the person who's now facing the allegation again with the same decision maker, and it could easily be the same decision maker because the league didn't change who they put in the place to make these decisions. If there's a prior example of a decision that was adverse, then the person facing the allegation would certainly not want, the decision maker to have that attitude of bias towards them. So again, they shouldn't participate. Institutional bias is Shivani, your hand's up.
Yeah, could you give an example of the prior one?
Oh, of attitudinal? All right, so John Smith regularly hears matters for Major League Baseball on issues of domestic violence. And Ray Rice, I'm saying baseball, but Ray Rice is a baseball player, and he had previously come before John Smith for domestic violence for a relationship he was in 2 years ago, right? And he's now has a new fiance, right, who he is now beat in an elevator, and he's now coming before the same person who decides domestic violence cases for the MLB, right? So Ray Rice's problem is going to be is that he's going to say, look, I've appeared before John Smith before. I appeared before him 2 years ago on a very similar kind of offense. And I think that he's now going to be predisposed to think badly of me because he's already ruled against me once before. So, I fear he'll rule against me again, partly because, his attitude towards me is affected by the fact that he already found me to be guilty of domestic violence before. Make sense?
Yeah, thank you.
You bet, you're welcome. Okay. All right, institutional bias. This is getting harder to prove because this is the kind of bias that is built into the system of organized sports. So, it's harder to show. And here's this is an example. So, for instance, leagues like the NHL and MLB, whatever, leagues are made up of teams, and teams all have owners, right? And the owners all operate as a group, as a cohesive group, because they're all dealing with the Players Association for all the players that work for them. Again, it's the billionaires and the millionaires, right? And so the league itself, the board of directors, which is the 30, MLB has 30 teams, NHL 30 teams. The teams have the board of directors are made up of owners or owners representatives. So they're the board of directors, and and those board of directors have other subcommittees, and one of the subcommittees may well be for a very specific for the firing of a manager, for instance. It's a bigger deal than firing a coach or firing a player, right? Managers, there's only one manager per team. So, and the manager is not happy with the fact that he was fired. So, he's going to an executive committee of the board of directors. And, and the board of directors, again, are the owners, and the manager is just an employee. And, and so he's going to, and if he's going before a board made up of representatives of the owners, he's going to feel that there's some kind of a bias because he's dealing with the owners. And clearly one of the owners has fired him, right? So the person who has fired him is a member of the club, the ownership of the league, right? That makes the board, that makes those decisions affecting him. So that's institutional bias in that the ownership group is making a decision affecting a complaint from an owner to somebody else. So it's one of their own to somebody like a manager. Okay, so it's within the institution. So now it's getting a little harder to prove these kind of things, right? And lastly, you have what's called operational bias. And that's the manner in which a tribunal, however it's set up, actually operates. So, clearly what happens for operational bias is if a hearing is convened, and again, it doesn't have to be that serious a hearing if it's somebody's livelihood not at stake, but if it's somebody's future is on the line, then it has to be, as we just talked about, a more structured hearing with more proper rules in place. And if the person or persons making the decision in that context exercise or make decisions that are clearly favoring one party over the other, right? As in it's clear that, they're favoring management over the players' rights or the coaches or management or managers' rights, those kind of things, then that's operational bias, in that the person who is sitting there watching how this tribunal operates is saying, "Hey, that's totally unfair. Every decision that decision maker makes is in favor of management and not me," right? So that's an argument you'd make. All right. Okay, so let's deal with what's called administrative appeals, right? So again, because sports organizations are private tribunals unto their own, right? Then, there is no omnibus law in place, common law in Canada, or statutory provision in place for the most part, that basically says that decisions that sport organizations make have to basically offer an appeal route to those decisions that are made within the purview of that tribunal. So if a league makes a decision on a suspension of somebody half a season or a full season for domestic violence, unless the league specifically has made allowance for it, there's no appeal of that decision. There's nowhere to go, right? Unless the league does that. But having said that, almost every league does allow appeals, right? Appeals of their own internal decisions to another group that is to a great degree internal as well. They do that because it avoids recourse to litigation. Because I guarantee you, somebody who's a player and whose career is coming to an end, who makes $10, $20 million a year, which is not uncommon these days, right? They're going to hire the best lawyer they can find to fight their case, right? And they're not going to just stop at the tribunal. They're going to want to go to court to have an impartial judge hear it, right? So again, sports organizations in very, very limited cases allow appeals to try to avoid the necessity of litigation. However, having said that, what is open to appeal is totally up to the organization itself, right? So it doesn't open the avenues for appeal, that widely. So the narrow approach that some leagues take, right, is that only matters affecting membership in the organization are open to an appeal. And that just kind of makes sense. Again, it deals with the severity of the allegation. So if a decision affects somebody's ability to play, right, then leagues, those who take a narrow approach will say, well, you know what, we don't really allow appeals of our decisions for the most part, but if it affects somebody's ability to make a living, we will allow an appeal in that case. Some teams take a broader approach and say, look, all matters affecting all rights of members are open to an appeal, right? And that's a very broad approach, and some leagues take that approach because that, to a great degree, eliminates totally the prospect of litigation, in that somebody's not going to sue them for not having an appeal route available to them, right? As a general rule, matters of policy are not open to appeal. Okay, so how a league operates, across the board, not with respect to a specific member or somebody individually doing something wrong, but what its policies are overall, those tend not to be open to an appeal. Organizations have right to set policies and they are to be followed, right? There is no appeal if a member is dissatisfied with the wording of the policy itself. However, an appeal will lie if the policy is not carried out. Okay, so establishing the policy is no, Rish? Oh, Rish wants in, sorry guys. There you go. So the policy itself isn't open to an appeal, but the application of the policy is, in that if the organization doesn't follow its own policy, then that is subject to being examined. So issues commonly appealed are these. So interpretation of the documents forming the contract, which again is the Constitution, the bylaws, the rules of the organization. So, if a player does not think that his or her team have followed the rules of the team or the rules of the game, then that is appealable. Again, allegations of bias are appealable. So clearly, for instance, if any one of those 5 relational, attitudinal, organizational, any one of those kinds of bias are alleged by somebody facing a disciplinary hearing and the tribunal rules against them, right? Well, then, the player doesn't have to stop there. They can take that issue to court, right? Because they're alleging that, in fact, they have not been treated fairly. And you can also appeal which organization has authority. So, does the team have the authority to make a decision that should better have been made by the league itself? Those kind of things. So those are very broad-based, somewhat constitutional kinds of claims. Okay. So here's an example of an organization and how things work. So, and this will probably be news for most of you. So national sports organizations select national teams, but not in multi-sport settings. So not in the Olympics, the Commonwealth Games, or the Pan Am Games. And we have Olympics in Tokyo in a couple of months, right? So that's Olympic Games. So the way it works is this: national sports organizations only nominate their athletes, right? The multi-sport organizations actually name the teams, right? So you can imagine, that if the National Swimming Association for Canada, whatever it's called, nominates this team, and for whatever reason the Olympics say no, the members of the team aren't going to be as you're putting forward, then that's going to be an issue. The problem with that is, of course, is that the removal of one member of a team with another, it creates a cycle of appeals. Because somebody's removed, they're going to appeal. The person who's put into their place, if the appeal is successful, they're removed. They will then appeal that removal. It goes in a circle. So, it becomes a very cumbersome kind of thing. And that's why appeals are restricted as much as possible. Members of organizations can always go to court, but with very limited scope. And, if you don't have a direct appeal on, again, a breach of the contract, the social contracts, the constitution, bylaws, or bias, if you don't have an appeal on those grounds, what you have is what's called judicial review, right? And judicial review, again, and this is very much within the purview of administrative law, is again only deals with the fairness of a decision. All right. So I'm going to show you. I'm going to read this, and I'm going to show you a couple of clips. So in 2015, the AFC, American Football Conference Championship game of the NFL, right, had what's called a tampering scandal, referred to as Deflategate. So some of you may remember, it's now 6-7 years old, so it's a little ways in the past, but it was a very big deal at the time, and it involved the tampering of footballs by the New England Patriots, i.e., its quarterback Tom Brady, together with guys who worked in the clubhouse, related to what was alleged is that they let air out of the footballs, and the teams are the ones that bring the footballs to the games to be played, right? The league doesn't provide them, the teams provide the balls. And the allegation is that the Patriots had deflated the balls ever so slightly, which gave Brady a better grip on them. He's the quarterback, and he's no longer with the Patriots, but he's still in his 40s and playing professional football. But it gave him a better grip on the ball, so that throwing as a quarterback, he had more accuracy. It was alleged that they did this in the AFC Championship game against the Indianapolis Colts in January 18th of 2015, which is the playoff season, just getting ready for the Super Bowl. All right, so here's the explanation of what this is all about. Okay, we've got that. And then we have the next timeline.
It has been more than a year and a full football season since we first learned about deflated footballs and air pressure gauges after the AFC Championship game in January of 2015.
I don't know what happened. I have no explanation for it. I don't know what happened between the time that I touched it and, really till Monday morning, I have no idea what happened with the balls.
The New England Patriots won that game and the Super Bowl 2 weeks later.
A fourth Lombardi trophy is headed to one Patriot place.
But they have been embroiled in controversy and in Tom Brady's case in court ever since. An NFL investigation found that some of the footballs the Patriots used in that game were not at the proper air pressure level. And it asserted that Brady was at least generally aware of a scheme to take the air out of the ball to give him a better grip. The Patriots angrily disputed the findings, but the league slapped Brady with a 4-game suspension and the team with the loss of first and fourth round draft picks and a $1 million fine.
Reluctantly, I'm going to accept what he has given to us and not continue this dialogue and rhetoric.
The Patriots chose not to fight their punishment, but Brady took the league to court last summer.
Free Tom Brady!
Free Tom Brady! Roger Goodell has said that Brady needs to bring new evidence to the table. Brady has proclaimed his innocence from day one.
Brady won at the district court level when Judge Richard Berman found that Brady was not treated fairly during the investigation and punishment process. He vacated the suspension just days before the 2015 season began, and Brady did not miss a game. But the league appealed, and in early March, a 3-judge panel at the hearing struck a tone that sounded far less sympathetic to Brady. The judges repeatedly asked about Brady destroying his phone while the investigation was ongoing. One judge called the evidence of ball tampering compelling, if not overwhelming. While the judges deliberated, the NFL went on with its offseason, with the immediate future of one of its greatest players very much in question.
For the last 20 years, I've been playing football this time of year, and it feels good to be able to do that again.
It is.
Yeah, and so I've said this before, football in the United States is a religion. I mean, it is like going to Sunday, every Sunday, a religion, right? So there was, no matter what the evidence was against Tom Brady, and the evidence was pretty clear that he in fact knew about the deflation of the balls and he took advantage of it. He knew it would, it would be a bet. They didn't need to cheat, right? They were a really good team anyway, but he decided to participate in that. So there was the 4-game suspension was put back into place as a function of the U.S. Court of Appeals, right? So in fact, there was that 4-game suspension, didn't take place until the beginning of the following year, which isn't nearly as important a period of time as it would have been if he was suspended during the playoffs the previous season when they actually won Super Bowl. So you kind of get how that works. And all of that, of course, is administrative law, right? The $1 million fine to the Patriot organization, the 4-game suspension, all the indefinite suspension of the guy in the locker room, all those things were administrative decisions put in place by the NFL, by Ralph Goodale, the commissioner of the NFL. And if you guys have watched Concussion, right? If you haven't watched it yet, and you're gonna watch it before Friday, or if you already watched it, and some of you have, because I have your Google Forms back in. You guys will all know all about Ralph Goodale, because he was the one that, to a great degree, was very important in that concussion conversation that took place during that movie. All right, guys. So that's it for the lecture itself. So it's pretty straightforward. So now we're going to do the breakout room. So there's 3 questions you guys have on Moodle. I'm going to put you into one of 3 groups, and again, give you 10 or 12 minutes to put your answers together and to come back and provide those to the class. Okay, here you go. Bring your questions now. Roll with them. What's wrong, Jared?